welcome. We are appreciative of your willingness to try this video argument. It's worked pretty well every time we've tried it, so I think this will work fine. Remember, there may be other people watching, and it will be recorded as arguments usually are recorded. The audio is for later placement on the internet. Mr. Hivner, would you call the case, please?
Jacob Daniel Drucker versus Colleen Erin Daley.
Okay. The appellant ready?
Unmute your microphone. There you go. There you go.
I'm sorry, I thought I was unmuted.
Yeah.
Okay.
We have a panel of youngsters that train us around here.
Well,
The only way we know what's going on.
I need to borrow one of them to help train me, sir.
Whenever you're ready, Mr. Pate.
I am ready. May it please the court, first of all, good morning. Stephen Pate of the Rutherford County Bar, counsel of record for the appellant, Colleen Daley, who I will refer to as the mother in these proceedings. I'll refer to the appellee as the father in this case. As you are aware, this is an appeal as a matter of right by the appellant mother from orders entered April 1st, 2019 and June 26th, 2019 by Magistrate Adam Dodd of the Rutherford County Juvenile Court. So there's no misunderstanding. Adam Dodd, the magistrate, tried this case to its conclusion, but we have an agreed order by Honorable Judge Donna Scott Davenport, judge of the Juvenile Court, entered July the 5th, 2019, allowing the magistrate's order to be the final order of the court, therefore waiving a de novo appeal before Judge Davenport. There is a single issue to be considered by this honorable court today, and that issue is whether the trial court erred in finding a material change of circumstances that existed directly affecting the party's minor child in order to justify a modification of the father's residential schedule. This is in the record, but not in the brief. This is a post-legitimation petition. And from the original order, the mother was deemed as the primary residential parent, had the old classic 265 residential time for herself, 80-day residential time for the father. Now, this court of the law, first, the petitioner, in this case, father, must plead and prove a material change of circumstances has occurred subsequent to the original order that directly affected the child in order to modify either custody or the residential schedule. And that's the first of the two-prong test. The second prong is if the court finds material change of circumstances, then it must determine whether a modification of the parenting schedule is ultimately in the best interest of the child. Now, the father originally petitioned the juvenile court and made a lot of very strong allegations against the mother. He alleged mental issues. He prayed for a psychological evaluation. He requested that the mother only have 30 days of supervised residential time during the entire year, but in his pleading filed no proposed parenting plan. Now, I wasn't counsel for the mother at the time of the trial. That was other counsel. On the day of the trial, February 4, 2019, father came into court with a proposed parenting plan and completely changed the position and simply said, I'm removing any prayer that the mother basically undergo a psychological evaluation or that her time be supervised for only 30 days per year, but simply requested, in summary, he wanted additional residential time to it to be a co-residential parent to have equal residential time with the minor child throughout the year.
Was there any objection once that plan was presented saying, look, we need more time here because this is a different plan than we had anticipated?
No, sir. There could have been. And if I had been her attorney at trial, I probably would have objected, and the court, I think, would have been compelled to continue the trial. I think they waived that deficiency by statute and just proceeded. So I'm not arguing that now. Now, in brief summary, at the trial, the mother testified and largely agreed upon with the father that the only change of circumstances post original order, which was about 10 years ago, was that the mother had moved with the child from Selmer, Tennessee, about 200 miles west of Murfreesboro, where she lived with her parents, to Rutherford County, Tennessee, and the child was obviously older. And that was
What about the aging of the child?
Well, the aging of the child is a factor by statute, but the aging of the child, of course, is inherent, whether you go 6 months or 6 years. By statute, that was one of the father's prayers. He said the child is now older. And so that was one of the facts regarding material change of circumstances he relied upon, along with the mother's relocation to Rutherford County from Selmer, Tennessee, down near the Tennessee River.
Wasn't that one of the factors cited by the trial court?
Yes, sir. It was.
Okay.
But here is where I must argue against that. In all cases, there are always change of circumstances. You can't go 30 days without something changing a little bit, but it has to directly affect the child. The aging of the child is inherent. We all age every day. It has to affect the best interest of the child. Just because the child is 9 or 10 years older doesn't mean automatically the residential time changes. You have to have an effect on the child. The mother testified in summary, I don't even look at the brief on this, and the father largely agreed that the child had done excellently in school, was largely a straight A student. Child was involved in extracurricular activities. The child was in the honors program, or I think they call it the scholars program, had done excellent. Was involved in extracurricular activities, was heavily involved in dance. And now that the child is older, she's actually instructing younger girls in dance. Mother was 95% responsible for transporting the child to and from school every day timely. Mother was principally responsible for the medical care for the child. The father conceded the child had done well, had progressed well, was doing well. There was, notwithstanding what he pled in his argument, the mother was basically deemed as a good, if not excellent mother, and the child was progressing well. The court found all of that. The court found that, and it's clearly in the record, that the child was well adjusted, well adapted, excellent in school, excellent extracurricular activities. No change had any direct effect on the child. The court literally stated, and I quote, the child is doing well. And the court further found both parents were good people, good parents, both live in good homes, good social network, child being well-adjusted, and the child being high functioning. So at the end of the trial, the court says there's no material change of circumstances to justify a change in custody. So this is a critical point. So literally in the same breath, so to speak, the trial court says no material change of circumstances directly affecting the child as to justify a change in custody. So left mother is the primary. But then in the same breath, he says, however, I think there's a material change in circumstances for a shared parenting schedule. So basically, to gut the current schedule of the 285, where the mother has 80 and obviously the father has 265, to a shared schedule. And that is exactly what the court ordered. In the testimony as to why the father wanted this schedule, this is of course clearly in the record. He states, well, because other than the lapse of time, he said he felt this was the right thing to do. He wants to play a greater role in the child's life, have a greater influence over his daughter. And the daughter needs to know what a good man he is and how much he loves the father. That's all in the record. But at the same breath, he says, no, but the child is doing well in school, straight A's, well adjusted, dance classes are excellent, mother has been a great mother, etc. Now, again, we have to differentiate just a straight material change of circumstances, to wit, the move and the passage of time to a change of circumstances that affects the child. And this is where, respectfully, a lot of both trial attorneys and courts sometimes miss the boat, so to speak. There has been no change of circumstances that affected the child, none whatsoever, simply none. And as the courts are well aware, our trial courts and appellate courts deem the continuity of placement critical and most important for the child. We cited the case of Ballard versus Kawabas, Cayabas, a similar 2017 appellate court case wherein the court found regarding material change of circumstances, the mother had violated the terms of the plan, but the terms of the plan didn't affect the child well-being in a meaningful way. In that case, the child was doing excellent in school, well-rounded socially, had good social network, and the court ruled that notwithstanding mother had violated the terms of the plan, her violation of the plan did not affect the child in a meaningful way, and therefore denied the change of custody and denied the change of the residential schedule.
Mr. Pate,
Yes, sir.
what about the policy of the law that the court should try and equalize the time as much as possible, where
Yes, sir.
practical?
Well, I understand that law was passed, 4 or 5 years ago, something like that, to maximize, the legislature uses the term maximize each parent's time. Yes, sir, that is clearly the law. And if these parties were legitimating the child today, that's what we would be facing. But you've got to remember, unless the court finds a material change of circumstances that has directly affected the child, the court cannot and should not use that standard to maximize each parent's time, because the burden is on the father, the petitioner, in this case, the father, to show the change of circumstances and how it has directly affected the child. Now, secondly, another error that the trial court made respectfully was, once the court found a material change of circumstances, then the court, and he gave the father obviously exactly equal residential time. Now, he kept the mother as the primary, but for one day, the father would have been obviously the primary residential parent. So he largely gutted the old plan. But here is where respectfully the trial court erred. Once he felt that the father had met the first prong of the two-prong test, finding material change of circumstances, the trial court failed to utter a single word regarding best interest, ignored best interest, didn't follow best interest, TC 36.6.401 subsection little a. What is there, about 14 factors the court is supposed to factor in? And the court by law must elaborate and state specifically why it was in the child's best interest on a point by point basis. And it's laborious to do. I've drafted many an order where you have to address all those, I think about 14 factors. The court didn't say a word about this. The record is void, literally void, of any reference to the best interest test. Just didn't say a word about it, not a word. So we leave the court with allegedly material change of circumstances, but no findings by the court, findings of fact as to best interest.
What about Mr. Pate? What about the father's argument here regarding waiver of this issue? The way your issue is framed on appeal, I appreciate that you argued that within the body of your brief, but the way the issue is framed on appeal, I would have never guessed that we even considered best interest in this case, because it's all about material change of circumstances and whether or not that affected. So how do you address that argument, the waiver argument?
Well, I'm not aware that there was a waiver argument in my appellate brief. We touch upon this issue on pages 23 and 24 of the brief, in particular, where there was, again, no findings of fact by the court regarding best interest, because it is a two-pronged test. And I didn't cite that in the sort of the bold argument, but it is clearly, where I have enumerated what the argument is at the very top of page 18 and on a separate earlier page on page 5. But we clearly address it right in the heart of the brief, pages 23 and 24, because that's the law. That's the statute. and the court failed to address it. Now, I'll be frank with you, I'm not looking for, I would hope, and I'm not asking for a remand to the juvenile court to enumerate the best interest of the child. What we're obviously praying for is that whole order to be reversed, set aside, and for this court to order that there was no evidence of a material change of circumstances directly affecting the child. So therefore, he didn't even have to go to the two-prong test. So therefore, the father's petition should be dismissed. We should go back to the original order that's now about 10 years old.
Okay, thank you. Your time is up. You still have the 2 minutes.
Thank you.
For rebuttal.
Yes, sir. Thank you.
Mr. Cope.
Yes, sir. Good morning. Thanks very much, and may it please the court. I'd like to start by addressing what I don't think Mr. Pate mentioned at all, which is the fact, as I cited in my brief, that mother had filed a counter petition in this same juvenile court custody litigation where she alleged affirmatively that there was a material change of circumstances. And specifically, she stated, quote, "The inability of the mother and father to agree on these issues has created a material change of circumstances." And that can be found in the trial record, volume 1, page 38, paragraph 5. So on that point alone, I think Mr. Pate's client has already stipulated that there's a material change. So that whole issue of material change of circumstances, even if you take everything Mr. Pate's saying at face value, which I disagree with his sort of the way he described the trial court's ruling, obviously, but even if everything Mr. Pate's saying is 100% true and accurate, it still didn't change the fact that mother herself alleged and stipulated that there had been a material change, granted on different reasons, but nonetheless had made that statement. The other point I think that mother misses is that there's obviously a different statutory standard with respect to modifying a residential schedule versus modifying custody. And I don't have to tell this court that. I know the court's well aware of it. But as the court also knows, the threshold, the evidentiary threshold for material change in circumstances to modify a residential schedule is very low. It's a very low burden when it comes to that. I would cite the court to the Armbruster case, which frankly has very analogous factors in terms of what constituted a material change. And in Armbruster, those two factors were the age of the child and the distance between where the two parents lived. And as the court knows from review of the record, these parties lived 200 miles apart from one another, and the child was 14 months old when this original parenting plan was adopted. The child was 10 at the time of trial, and the parents literally, as the crow flies, lived approximately a mile or two from one another in literally adjacent subdivisions. So it's not even like mom moved to Nolensville and dad lived in Smyrna. They lived in the next subdivision over. So I think with respect to the material change, I think those factors are pretty strong in favor, and that's what the trial court cited. To Judge McBraier's point, that is a point I raised in my brief. It was not clear to me at all that mother was taking issue with the best interest analysis. It was tacked on at the end of his brief, not as part of his grounds for appeal, but almost as a throwaway that, oh, by the way, in the event you agree with the father's position that there's been a material change, the court didn't do a best interest analysis. So to Judge McBraier's point, that's something I think that is important to note. But even if the court considers that, I think Judge Dodd did a really, really good job of going through why he thought the parenting plan that he created. And I think that's another point for the court to consider. The trial court did not adopt my client's proposed parenting plan. The trial court didn't adopt mother's proposed parenting plan. The trial court adopted its own parenting plan, which granted was a variation of the one that we proposed. But the trial court is allowed to do that. The trial court's not limited to the proposed parenting plans of either the father or the mother. So in this instance, the trial court was free to do that. And the last point I would make is this: as this court knows, the trial court is not obligated to go point by point on the custody factors and say whether or not each factor weighs in favor or not. the court can discuss all the factors by not specifically naming them. And I think the record reflects the trial court did that. But that's all I have, and I'm happy to answer any questions.
How many days of parenting time did the father have under the original plan?
That's a great question. It was very low, Your Honor. I don't remember off the top of my head, and I apologize for that. It was not much. I think it was every other weekend or maybe one weekend a month.
Okay, go ahead, Mr. Pate.
80. It was the old classic. Father had 80, mother had 265.
All right, thank you.
Yes, sir.
Any other questions for Mr. Cope? Well, seeing none, thank you.
Yes,
and
sir.
let's go back to Mr. Pate. I believe you have 2 minutes reserved for rebuttal.
Yes, sir. Thank you. 2 points. Again, I was not trial counsel, and I realized mother's pleadings contained an allegation that the parenting plan hadn't worked at that time and therefore constituting material change of circumstances. I can see that's what the pleadings say, but that's frankly inconsistent with mother and father's testimony. They testified that actually the plan had worked well. Mother testified and father confirmed that on occasion when he wanted additional time, she allowed it. And so there was no evidence to that effect. But number two, regardless of the pleadings, respectfully, the case law to me is clear that you have to have a material change of circumstances directly affecting the child. And sometimes we confuse the change of circumstances with the effect on the child. There can be change of circumstances, but if no effect on the child, then ultimately that threshold is not met. So before you get to the second prong of the two-prong test, to wit, best interest, you have to have the evidence showing that whatever change of circumstances occurred affected the child. And even the father conceded the child was doing well, and the court confirmed the child was doing well academically, socially, family-wise, etc. No effect on the child, none. And the court agreed with that. And the court simply said, well, but we're still going to give the father equal residential time. And respectfully, I'm submitting the trial court erred. Thank you.
Well, thank you, Mr. Pate. Thank you, Mr. Cope. And Mr. Hivner, could you adjourn court, please?